Ms. Hawkins, how did the child that passed, Lilith, how did she get placed without any? When you learned of her death, you put a diaper on her because she didn't have any clothes on.
Yes.
Why wouldn't she have had a diaper on the night before, or some kind of clothing the night before?
We were trying to potty train her, so we were trying to get her used to not wearing diapers, and we didn't have any clothes to put her in, and
Okay. With that said, State, would you like to be heard?
Yes, Your Honor. In this matter, the plea negotiations had a stipulated sentence of 30 months in count 3 to run consecutive to 30 months in count 5 to run concurrent to 30 months in count 7 for a total of term of incarceration of 60 months or 5 years, Your Honor, total. The state of Ohio came to that conclusion in light of all the evidence looking at what involvement Ms. Tian Hawkins had compared to that of Mr. Brian Moser, and that's how we came to the conclusion of the stipulation of the 5 years, Your Honor.
Is there a reason that the one so there's 3 different children in counts 3, 5, and 7? 30 months are recommended and agreed on 2 of those counts, but the third count is concurrent. What was the basis of the third child not having a penalty factor?
So basically, the reasoning for that, Your Honor, is we're going to do 15 months on each. However, that's not allowable under the laws for F3. Those two children, they were kind of treated the same in regards to her actions and that, and so we wanted a 30-month total for those two, but we couldn't do it by 15 and 15, and then otherwise we'd have been left with 12 and 18, and that wouldn't have made sense either, because then one would have been more than the other, so that's why we did 30 to run them both concurrent, so we still got the 30 that what we wanted or intended to get for those two children, but there was no way to get that with the current allowance of times under the law to make it be the same.
Also known as Brian Moser, was read his Miranda rights. He stated that he had changed his name because he likes the character from the TV series Dexter. He said that he put all the kids to bed around midnight. He then went to bed with his fiancee Tian. She was already asleep, being 10. Brian said that Aurora was to the left of the bed, Lilith was in the middle, and Isabel was on the right. He thought it would be cute for all three of them to be up on the top bunk like that. Detective Cooley explained to Mr. Moser about the bump on the head and asked about that. It had to be a hard impact to cause that type of bruising. Brian Moser said, "I did not hit her in the forehead. I did not. I could put that on everything. I don't recall hitting them anywhere but on their butts, hands, or their mouth. I did not close fist hit them. I don't do that." And it concludes by saying that Deputy Cooley advised that this isn't Dexter, this is real life.
Yes, Your Honor, thank you. We are asking the court to follow the agreed 5-year sentence. I think there's no doubt that this case presents an unimaginable tragedy, Your Honor. But Ms. Hawkins is 26 years old. She has no prior criminal history, and I think it's important to distinguish the intentional acts of Mr. Moser versus Ms. Hawkins's involvement with the failure to protect the children. The majority of the abuse that was happening was occurring while Ms. Hawkins was at work supporting the family, and she entrusted Mr. Moser to become the full-time daycare provider for the children, unbeknownst to her, of the horrific things that were happening. And I think Ms. Hawkins shows a genuine remorse for what's happened. She's able to realize now what she didn't realize at the time. And it's important to note that she has a family here that's provided unwavering support for her. They've attended every hearing. We've provided letters, not only from her family, but from the community, trying to show the court what kind of person Ms. Hawkins is and what she is capable of providing to society. We think no matter what happens today, when Ms. Hawkins leaves here today, she's going to be stuck with a life sentence of guilt and remorse. But we are asking the court to follow the 5-year agreed upon sentence.
You're welcome. Ms. Hawkins, under Criminal Rule 32, you're not required, but you're entitled to make a statement on your own behalf if you wish to make a statement. I realize that you've given a statement to the officers that prepared the pre-sentence investigation report, but is there any statement you'd like to make today, ma'am? And if so, now would be the appropriate time.
Just that I love my children and I wanted to give them the best life I possibly could. And if I knew what he was doing, it would have never got as far as to what it did. And that I would still have all 3 of my children.
has shown that she carries a folder with the pictures of her children with her, and often refers to them. With that said, the questions that I had about following the stipulation of sentence was why the third child was treated differently. The court has struggled with whether a 30-month sentence should be placed on each child, and again, I think I don't find that to be harsh when we look at the realities of this. And so that's the court's concern, and then also how the child ended up. And I realized sometimes children sleep naked, but there was just no guardrails there. And I ask in cases sometimes, would you go to the grocery store and sort through all the apple bin and pick out the bad apple and bring it home to your children? And mothers always say no. But you sorted through the apple bin and found this Brian Moser, bad apple. You knew he was a bad apple. You saw the change in his behavior, and you didn't put up any guardrails. And I struggle with that. Do you want to comment on that? You don't have to. Okay. Well, sometimes the court has to consider what the citizens and the community partners, what they have observed, what they know, what they have experienced, that they have interacted with Ms. Hawkins. This court, obviously, it's been very limited. The court has interacted with Ms. Hawkins. I do believe that Ms. Hawkins has great remorse for what occurred. There is a high likelihood there will never be recidivism in this case. Even in light of the court's concerns as to the variation in the agreement, the court does find comfort, especially in your in the very well written letter by your former Sunday school teacher that I thought she captured very well the person that we didn't know that she did know and did know. So it will be the order. Of the court that the court, with some hesitancy, but finalized that after due consideration, the court finds the defendant is not amenable to available community control sanctions. The court does intend to follow the stipulated prison term, and it will be imposed that the defendant shall serve the stipulated prison term in count 3, of 30 months, a stipulated prison term in count 5 of 30 months, which shall be served consecutive to count 3, and a stipulated prison term in count 7 of 30 months, which shall be served concurrent to counts 3 and 5 for a total of 5 years incarceration in the Ohio Department of Rehabilitations and Corrections. Because multiple prison terms are being imposed on Ms. Hawkins for convictions of multiple offenses, the court may require that she serve them consecutively. Because the court finds that consecutive service is necessary to protect the public from future crime and or to punish the offender, and that consecutive sentences are not disproportionate to the seriousness of the offender's conduct or the lack of conduct and to the danger that it poses to the public. And the court makes the finding that at least two of the multiple offenses, in this case 3 offenses, that two of the multiple offenses, at least 2 of them, were committed as part of one or more courses of conduct, and the harm caused by 2 or more of the multiple offenses so committed is so great or unusual that no single prison term for any of the offenses committed as part of any of the courses of conduct would adequately reflect the seriousness of the offender's conduct. The court finds that the defendant's placement or transfer into a transitional control program under 2967.26 while incarcerated, or her placement or transfer into an intensive program prison under 5120.032, both are hereby specifically reserved by this court for denial upon notification that the Ohio Department of Rehabilitation and Corrections desires consideration of the defendant for transitional control or for the intentional program prison. Before I give the appellate rights, I'll start with the state. Do you feel that the court has complied with the stipulated sentencing agreement as presented to this court?
Yes, Your Honor.
Defense counsel, same inquiry.
Yes, Your Honor.
Very well. Ms. Hawkins, do you believe the court has imposed the sentence that you had stipulated or agreed to with the state of Ohio?
Yes, Your Honor.
Ms. Hawkins, this is now a final appealable order. You have the right to appeal this court's decisions, but you must do so in a timely manner. You must do so within 30 days of today's date, for I intend to sign this judgment entry of sentence today. As a United States citizen, if you cannot afford the cost to file that appeal, then you have the right to file that appeal free of charge. If the court possesses documentation that you need to promote your appeal of this court's decisions, then upon your request, again, the court will provide those documents to you free of charge. If you cannot afford the cost to hire counsel to represent you effectively, as the court firmly believes that both Ms. Carrington and Mr. Walker have done in this underlying matter, then upon your request, the court shall forthwith or right away appoint an attorney to represent you. But you will be required, Ms. Hawkins, to pay a $25 energy counsel fee fund. Ms. Hawkins, I stress to you and I emphasize to you, you must file that appeal within 30 days of today's date. Ms. Hawkins, do you feel you understand your appellate rights?
Yes, Your Honor.